Welcome, dear students. Today our topic of deliberation is divorce under Muslim law. The objective of this lecture are multifold. It first introduces the student to the concept of divorce in general. Secondly, it provides a brief understanding of how notions of divorce existed in pre-Islamic Arabia. This is important because it contextualizes how the Prophet, peace be upon him, subsequently addressed these issues. Thirdly, this lecture introduces the students to the notions of divorce after the advent of Islam and thereby becomes the basis on which the subsequent chapter talks about the practice of divorce in modern times. However, there are four main parts to this lecture. The first part of the lecture provides a brief introduction to the concept of dissolution of marriage. The second part discusses the notions of divorce as it existed in pre-Islamic Arabia. The third part discusses the same after the advent of Islam. And finally, the fourth part discusses the various modes of dissolution of marriage under Islamic law or Sharia. Now let's begin with the introduction. Marriages are for a lifetime. No person decides to marry without having the intention to spend the rest of his or her life with his or her marital partner. However, since marriage involves getting together of two people who come from different families and different backgrounds, different situations and different circumstances, problems may arise where it is not possible to carry on the union between the two people. The concept of divorce comes into play in order to deal with such situations. Now let's look at the divorce in the pre-Islamic background. The rules of divorce as they existed in pre-Islamic Arabia were deeply rooted in the unfair, unjust and torturous treatment of women in general during that era. A lot of literature on that period categorically suggests that the condition of women in pre-Islamic Arabia was a deplorable and inhuman. And arbitrary rules of divorce which existed during that time were just one of the many examples of how the men in that particular society exploited the woman. During the pre-Islamic Arabia, the husband held unlimited power as far as divorce was concerned. He had the power to pronounce divorce unilaterally and at any time, for any reason and in some cases without any reason at all. Moreover, he could also swear not to have intercourse with his wife while living with them. The husband could also arbitrarily accuse his wife of adultery, and this was used as a powerful weapon by the husbands against their women in order to exploit them. According to Abdul Rahman, at least four various types of dissolution of marriage were known in pre-Islamic Arabia. These were talaq, ila, zihar and khula. A woman, if absolutely separated through any of these four modes, was probably free to remarry, but she could not do so until some time, called the period of iddat, had passed. Now let's look at how the divorce looked after the advent of Islam. The Prophet of Islam, peace be upon him, looked upon these customs of divorce with extreme disapproval and regarded their practice as reasons calculated to undermine the foundations of the society. It was impossible, however, under the existing conditions of the society to abolish these customs entirely. And therefore, the Prophet, peace be upon him, had to mold the mind of an uncultured and semi-barbarous community to a higher development. Accordingly, he allowed the exercise of power of divorce to husbands under certain conditions. He permitted to divorced parties 3 distinct and separate periods within which they might try to reconcile their differences. But should all attempts at reconciliation prove unsuccessful, then in the third period, the final separation became effective. Now, on the basis of this, let's now look at what are the different modes of dissolution of marriage that exist in modern times. The various modes under which marriage can be dissolved under Islamic law can be categorized into following categories. Number 1, by the death of husband or wife. Number 2, by the act of the parties. And number 3, by judicial process. Let's start with part 1, by the death of husband or wife. It is clear and natural that with the death of husband or wife, the marriage ties comes to an end. When the wife dies, the husband can remarry immediately. But if the husband dies, the widow has to wait till the expiry of iddat, that is 4 months and 10 days, and if pregnant, till the time of delivery. Number 2, by the act of the parties. Now, another form of dissolution of marriage under Islamic law is where the parties themselves choose to dissolve the marriage, and this can itself be classified into following categories. Number 1, dissolution by the husband. Number 2, dissolution by wife. And number 3, dissolution by mutual consent. Now, let's look at how the husband can dissolve the marriage. So, by the husband. The husband can dissolve the marriage in 3 ways. A, by talaq. B, by illah. And C, by zihar. Now, the talaq, in its literal sense, this Arabic word, that is talaq, means taking off any tie or restraint. And in law, it signifies the dissolution of marriage. In Hanafi law, no special form or phrase is necessary to pronounce talaq. However, in the Shia law, strict adherence to a form is insisted. That is, it must be in Arabic language, uttered orally and in presence and hearing of 2 male witnesses who should be honest and virtuous Muslims. Even the presence of wife is not required. The talaq would be deemed to have effect on the date the wife came to know about it. Now, talaq itself is of 2 types, known as talaq-e-sunnat and talaq-ul-biddat. Talaq-ul-sunnat is a talaq which carries the approval of the Prophet, peace be upon him. It may be in the most approved form, that is known as ihsan, or simply in an approved form, that is known as hasan. Ihsan is the most approved form of talaq. Hidayah brands it as the most laudable divorce, where the husband repudiates his wife by a single pronouncement in the period of tuhur, that is purity, which means when the wife is free from her menstrual courses, and that he has not had intercourse with her during such period, so as to leave her to observe the period of iddat. This form of talaq remains revocable during the period of iddat. This form is most approved because the companions of Prophet, peace be upon him, approved of it, and secondly, because it remains revocable. Talaq-e-ihsan becomes irrevocable on the completion of the period of iddat. In talaq-e-hasan, the husband successively pronounces divorce 3 times during consecutive periods of purity, tuhur. It is therefore a divorce upon a divorce, where the first and second pronouncement are revoked and followed by third. Only then the talaq becomes irrevocable. Let's take an example to discuss this. A wife is in tuhur, that is period of purity, and without having intercourse with her, the husband pronounces talaq. Then he revokes it either by words or by intercourse, and menstruation follows. Again, when she is in tuhur and before intercourse, the husband pronounces talaq. Then what happens? Intercourse follows and menstruation follows. Now the third time, during tuhur, without having intercourse, he pronounces talaq. This is final and the divorce becomes irrevocable. Talaq-e-hasan comes into force on the very point when the third pronouncement is made, and iddat has no influence on it. Now let's look at the second form of talaq, that is talaq-ul-biddat. Here, the husband does not follow the approved form of talaq, that is talaq-e-sunnat, and neither pays any attention to the period of purity nor to the abstention from intercourse. Also known as triple talaq, Hidayah defines talaq-e-biddat as a divorce where the husband repudiates his wife by 3 divorces in one sentence, or where he repeats the sentence separately thrice within tuhur. Such a divorce is lawful, although considered as sinful in Hanafi law. But this form of talaq in Shia law is not permissible. Thus, a husband may pronounce, I divorce you, I divorce you, I divorce you. This is triple talaq. Or he may simply say, I divorce you thrice. However, the Supreme Court very recently, in the case of Shaira Banu versus Union of India, declared triple talaq as unconstitutional. Let's move on to the second form of divorce, that is known as illa, that is vow of continence. Illa is when a person swears that he will not have sexual intercourse with his wife and abstains from it for 4 months, and that is when the divorce comes into effect. The Shafis and Shias considered that such a vow does not amount to divorce, but it only gives the wife a ground to seek judicial divorce, while as the Hanafi jurists consider it a valid divorce and no legal proceedings are required. However, they believe that since the husband acted unjustly towards his wife, it is equitable that on expiration of 4 months, he should be deprived of the benefit of marriage. However, after the expiry of 4 months, the husband has the option of cancelling illa with the consent of his wife. And however, we should keep in mind that illa is not something that is practiced in India. The next form of dissolution of marriage by the husband is zihar, which is also known as injurious comparison. The zihar signifies a husband's comparison of his wife with his mother or any female relation within prohibited degrees. The uttering of zihar does not by itself dissolve the marriage. Its legal effects are that sexual intercourse between them becomes unlawful till the husband has expiated himself by performing penance. And number 2, the wife can claim judicial separation or even a regular divorce if the husband continues to behave irresponsibly in this fashion. Now let's look at how the wife can dissolve a marriage. Moving on to understand how the wife can exercise the option of dissolving the marriage. The wife does not have a prima facie right to dissolve the marriage. She has what is known as delegated divorce or talaq-e-tafweed. Now Bailey defines talaq-e-tafweed as a man may in person repudiate his wife, so he may commit the power of repudiating her to herself or to a third party. The husband delegates the power of divorce to his wife, and the Indian high courts have repeatedly held as valid the agreement by which the husband authorizes the wife to divorce herself from him in the event of his marrying a second wife without her consent. Now, following elements need to be satisfied in such a case. Number 1, the delegation must be in clear terms. Number 2, the circumstances in which the wife is to exercise the choice must be also spelled very clearly. And number 3, the conditions must not be opposed to public policy. Let's move on to the third part, that is dissolution of marriage by mutual consent. There are 2 ways in which the doctrine of mutual consent can be used to dissolve marriage. These are number 1, khula, and number 2, mubarat. Let's look at khula, which is also known as redemption. If the mutual relation between husband and wife is not good, the wife, if she so desires, may seek a khula divorce by relinquishing her claim to the dower. It, however, entirely depends upon the husband to accept the consideration of dower and to grant such divorce. Moreover, a husband may similarly propose a khula divorce to the wife, and the wife may accept or refuse it. However, if she accepts, it means that she has relinquished the right to get dower from her husband. Now let's look at mubarak. When the divorce is effected by mutual consent of the husband and wife, it is known as mubarak, that is freeing one another mutually. The third form of dissolution of marriage is by judicial process. Now, in relation to this also, there are two forms in which judicial process can be employed by parties to dissolve marriage. Number one is called liam and number two is called fasq. Let's look at liam, also known as mutual imprecation. In this case, the wife is entitled to sue for divorce on the ground that her husband has falsely charged her with adultery. The procedure for the same is as the wife files a suit for divorce on the ground that the husband has falsely charged her with adultery. Next step, if the husband withdraws this charge before the completion of the trial, the court shall dismiss the suit and no divorce shall be granted. However, if the husband is persistent in his attitude, then he will have to accuse his wife on oath. This will be followed by an oath of innocence by wife, and after these mutual imprecations, the court dissolves the marriage. The next part is fasq, that is also known as judicial annulment. This is governed by the Dissolution of Muslim Marriage Act 1939. Before this act, a Muslim woman had the option of seeking judicial annulment of marriage on following grounds. Number one, annulment because marriage was irregular. Number two, annulment in exercise of right of option called khairul bulugh. Number three, annulment because the marriage was within the prohibited degrees of relationship. Number four, annulment because of post-marriage conversion of the parties to any other religion. Next, annulment because of impotency of the husband. Next, annulment because of liam. However, after this act came into force, the grounds on which the Muslim woman can seek divorce is provided in section 2 of this act, which provides a woman married under Muslim law shall be entitled to obtain a decree for the dissolution of her marriage on any one or more of the following grounds. Namely, number one, that the whereabouts of the husband have not been known for a period of 4 years. Number two, that the husband has neglected or has failed to provide for her maintenance for a period of 2 years. Number three, that the husband has been sentenced to imprisonment for a period of 7 years or upwards. Number four, that the husband has failed to perform without reasonable cause his marital obligations for a period of 3 years. Number five, that the husband was impotent at the time of marriage and continues to be so. Number six, that the husband has been insane for a period of 2 years or is suffering from leprosy or a virulent venereal disease. Number seven, that she, having been given in marriage by her father or other guardian before she attained the age of 15 years, repudiated the marriage before attaining the age of 18 years, provided in this case the marriage has not been consummated. Next, that the husband treats her with cruelty, that is to say, A, the husband has habitually assaulted her or made her life miserable by cruelty of conduct, even if such conduct does not amount to physical ill treatment. Or B, associates with women of evil repute or leads an infamous life. Or C, attempts to force her to lead an immoral life. Or D, disposes of her property or prevents her from exercising her legal rights over it. Or E, obstructs her in the observance of her religious profession or practice. Or F, if he has more wives than one, does not treat her equitably in accordance with the injunctions of Quran. Or on any other ground which is recognized as valid for the dissolution of marriages under Muslim law. Dear students, that was all about today's lecture, that is divorce under Muslim law. Hope you have understood it well. We shall meet again with new topic. Till then, take care of your good self. Goodbye.